case briefs, and so much more. LSData's got what you're looking for.
In a groundbreaking 1986 ruling, the Colorado Supreme Court shed light on the joint liability principle in a case, famously known as Brochner v. Western Insurance Company. The legal doctrine being scrutinized was that of joint tortfeasors being held accountable for their own negligence, and their right to seek contribution from co-defendants only relative to their degrees of fault, ruling out the possibility of seeking indemnity for co-tortfeasors' independent negligence. The catalyst behind the lawsuit can be traced back to a medical malpractice case. Both a hospital and a doctor, Dr. Reuben Brochner, were found to be complicit in causing a patient's injuries, resulting in an appeal by the hospital, asserting that the responsibility for the payout of the doctor's legal fees should be shared between them. In its ruling, the court emphasized that the Uniform Contribution Among Tort-feasors Act did not in fact eliminate the common law doctrine of indemnity, rather necessitated its modification. The drama unfolded when the hospital granted staff privileges to Dr. Brochner, who consequently performed a series of craniotomies. Ongoing reviews, however, concluded that many of the tissue samples appeared normal, prompting the hospital to place restrictions on Brochner to require consultation prior to carrying out craniotomies without clear pathology. Tragedy struck in 1968, when a craniotomy performed by Brochner resulted in an injury, giving rise to a lawsuit filed by the patient against both the doctor and the hospital alleging negligence. Despite reaching an independent settlement with the patient, the hospital was embroiled in separate negotiations regarding Brochner's compensation. With the ruling, the court sparked a necessary reform in the indemnity doctrine with the introduction of contribution among joint tortfeasors. Keeping in line with the act, the hospital was precluded from seeking indemnity from Brochner, but could only seek contribution. The Colorado Court of Appeals erred in awarding the doctor the defense costs, prompting the Supreme Court to reverse the judgment and reinstating the general rule against attorney fees.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of climb.